Mr. Jones.
Good morning, my lords. I appear on behalf of the appellant, City Outdoor Media Limited. My learned friend, Mr. Merritt, sits beside me. Mr. Dale Harris appears on behalf of the first respondent, Secretary of State for Housing, Community and Local Government. Manchester City Council, the second respondent, do not appear and have not participated in either the High Court or these proceedings.
Yes.
As I say, my lord, I appear on behalf of City Outdoor Media Limited. As we explained before the court, it is responsible for all the advertisements on a site which is owned by ECP, which you may see is run a car park on the site. But City Outdoor Media are responsible for all the adverts, including the car parking ones, and are also, as part of their needn't know, but as I explained to the High Court, contractual arrangements, also representing the interests of ECP, although ECP do not appear and have not participated.
I should say at the outset, we've done our pre-reading.
Yes.
The points seem very short, really.
Yes.
So we yet have hopes of finishing before lunch. But we'll
Yes.
see how we go.
Well, we thought, so that, well, I agree. I think I'll be an hour and a half.
Yes.
And hopefully, I was going to open that in essence, our grounds of appeal, just your lordships will have seen, it's one ground and there are three supplementary A, B and C explanatory. It's page 16 of the bundle.
Just not pursuing ground 2, Mr. Jones, which I was rather surprised to see there.
Ground 2.
The Putney Bridge was wrongly decided.
That was part of ground 1. If you're against us on ground, well, our point is actually it's still very simple. We don't think the judge below correctly interpreted Putney Bridge, and in any event, it would be per incurium because it's not dealing with this set of circumstances.
Well, hang on, but I wasn't trying at all to
yes.
Take you off your course. But ground 2 is that Putney Bridge was wrongly decided, which is in respect a ground that shouldn't have been pleaded because we can't do anything about that. We're bound by it. But
yeah.
You can argue about what it decides and whether it's distinguishable.
Yes.
But you can't say it's wrongly decided in this.
No, but we if and I big if obviously if matters would go further, we'd want to make sure that we had maintained, if the interpretation is of the High Court and if this court goes with it, we would be saying we'd want to reserve the point of arguing it was wrong, but essentially for the reasons that we're setting out in the main ground in any event. But we don't believe Putney Bridge, it's our submission to this court, Putney Bridge doesn't say what the learned judge says it says, or indeed what the Secretary of State seeks to rely on it. By way of housekeeping, you will have had the core bundle, supplementary and authority, skeleton arguments. My learned friend updated his skeleton argument for some reason. We'd got it with the bundle, the page reference, but he hadn't, and we had confirmation that that has been passed to your lordships.
Yes, can I just mention two things? For some reason entirely the fault of the court, not of either of you, I haven't got the authorities bundle. I did have it for pre-reading, because I borrowed my lord's. They're trying to track it down. If you have a spare copy, yes, that's terrific. As soon as you give it to me, it'll be brought to the door. Thank you very much indeed. Also, although I got the updated respondent's skeleton, I have failed to bring it with me, but if it's any updated with references.
It is only the references, yes, it's the bundle.
So, my lords, we say the core question is where, as we believe, it's common ground, the burden is on the local planning authority and then on the inspector to justify to the requisite higher test the removal of existing lawful rights. Where a decision notice is discontinuance notice is found to apply throughout to the removal of all deemed consent for the site, as opposed to, which, and I'll come on to in a moment in due course, a specific advertisement display, or as in Putney Bridge, a notice confined to a category or class. It's unlawful to uphold that notice without justifying its full scope. And that's a matter of jurisdiction and reasons and evidence. And so just three sort of preliminary points we say about the decision notice are, and then I'll highlight the structure of my submissions and then go to them. We say there's a disconnect when you look at the local planning authority's intention, and I'll take you even to the covering letter, its evidence in its case, and the decision notice as drafted, and indeed the inspector's approach. And number one, the decision notice, when we look at it, is Schedule 1, and I'll come to all this in due course, targeting a single advert. And then when you see the reasons, second schedule, again, it is targeted at that advertisement and nothing else in respect of the total removal for the display of advertisements under deemed consent for the site. And that's the third point. The actual effect of the notice is to remove all deemed consent and to make criminal the existing, for example, car park directional notices. And we'll come on to see how Manchester City Council put its case on that when we look at its statement of case. And when we look at the inspector's consideration, he only, as I say, considered the one advert, but removed all deemed categories. Now, it's going to be part of our submission that the burden, which is clear and is not in dispute, and it's a heavy burden, is on either the planning authority and then the Secretary of State in their shoes to justify the scope of the notice. It is not, and that's why I know my Lord Justice Dove will be very familiar with cases, planning appeals, where appellants say, well, the inspector didn't consider this alternative, didn't consider that, and rooting about for alternatives. Those are in circumstances quite different to these. This is a draconian power withdrawing a right which the Secretary of State, through legislation, has given to a site. And it's a site rather than an advertisement. So the structure I intend to take is in 6 points. Just so look at the legislative framework briefly, including the advice. Secondly, the background to the notice and the correspondence and the documents. This was determined by a hearing, the statements of case and replies. Briefly, the practical effect of the decision notice. And then 9, I'm going to look, sorry, not 9, fourth point, look at what we say is the correct ratio of Putney Bridge. Then I finally turn to the decision letter itself, which can deal with, and the judgment below, and then I'll deal with my learned friends' submissions. So that's the structure. And I intend first to go to the legislative framework and make a number of preliminary points, quite short, 5 points. The first point is, as we'll see, any display of an advertisement that doesn't have deemed consent or express consent or is otherwise out with the regulations is a strict liability criminal offence. And that second point, that can be contrasted with wider town and country planning, with the exception of listed buildings, which has its own regime. A breach of planning control may be the subject of enforcement action, maybe. Local planning authority has a discretion and has a range of powers. The issue of an enforcement notice under section 172, which requires a breach and the local authority to be satisfied on expediency. They may seek injunctive relief, which is within the discretion of the High Court. But it doesn't become criminal until there is non-compliance with an enforcement notice. So, against this background, the fourth point, deemed consent has been carved out, analogous a bit with permitted development that you have in more wider planning, but has been carved out as prescribing subject to conditions, and we'll look at those, none of them apply here, as to something which is acceptable without the need to apply for a specific express advertisement consent. And I just add to that point, it's important because it sets out with whatever is sufficient clarity, as the Secretary of State must determine by the regulations, a category of advertisements to require as acceptable. So that means if you own land to which these deemed classes apply, you can be assured that if you stay within that category, you don't have to go to the trouble and expense of applying for planning permission for those advertisements. The fourth point is deemed consent therefore means, by definition, as with express consent, the advertisement is not criminal. And then lastly, we have two different, therefore, types of permitted display, express and deemed. But as I've touched upon, they are different categories, because if you apply for express consent, you need to apply and say what type of advertisement expressly, and you're free to put in whatever you want. But if you're within a deemed consent, you just need to make sure, and we'll look at that you come within that categorisation. And the one that's obviously particularly obvious in this case are the directional signs for the car park that are on display here. But the point is, of course, and I'm going to go now on and we'll look at the regulations. The point, of course, is that the removal not only of a right to display an advertisement or a category, but the complete removal from a site means that this site in Manchester, unlike any other site, doesn't have what anyone else in the nation would have on their piece of land, those category of deemed consents.
Well, that's no different from an Article 4 direction, isn't it?
Well, that's right, and as your Lordship will know, with an Article 4, well, in that sense, an Article 4 direction, and also when you impose conditions, you grant planning permission, and you withdraw permitted development rights. And it's by analogy, there's well-established...
There's nothing to prevent you making an application for that which has been precluded. I mean, we have an extension on our house with a condition that says it can't be separately occupied. Yeah. That doesn't mean I can't apply for permission to say, actually, the reasons for you imposing the condition no longer apply, or there's a change in circumstance which requires that condition should be discharged. And same with my house, which is subject to an Article 4 direction. If I want to put up a greenhouse, I can make an application for it, and it'll be judged on its merits.
Yes, but no. If I can address your Lordship on that. The first point is, with the analogy with permitted development rights, we're not at the first stage is, first of all, with permitted development rights, and your Lordship will know the established case law. We haven't cited it, but it's on PD rather than an advertisement consent. But if we are taking the analogy, if you withdraw it, you've got to justify it and give clear reasons. You can't just, in this case law, just withdraw permitted development rights here and there. It has to be justified, and that's the crux of this case. So you couldn't just take your lordship's house. I couldn't just grant you withdraw a whole category of permitted development rights with no justification at all, and withdraw all of your permitted development rights for your lordship to use your one of your rooms as a quasi study, or for your judicial work now, or your previous bar work, when they're concerned about whether you're going to put a gazebo in the back garden. So the other thing, of course, is there's a different point here as well, which means it is no answer in this case to say, well, you can go off and apply for advertisement consent. Because if the decision is upheld, it is a decision that, to a higher threshold, as we'll see, the use for this site for any display of any of the categories of deemed consent causes substantial harm to the amenity. And that is a higher threshold than what would be needed if you were applying for advertisement consent. So I can apply and say, look, this advertisement, should be given express consent. And the local planning authority would be entitled to say, we take into account the Secretary of State's decision, the inspector's decision, and there's case law, as your lordship will know, that is one, a material consideration, and there's a decision of this court, Havard, that says it's of a higher level than previous decisions of the local planning authority itself, because it's by an inspector appointed by the Secretary of State, and that becomes a substantial material consideration against the grant of consent. And I wouldn't be able, my client, if they wouldn't be able to say there's been a change in circumstances, because there hasn't been. Nothing has changed, as far as I'm aware, since the inspector's decision was given. So it's not quite the analogy with respect that your lordship puts, because the key point is, this is the withdrawal of rights which the Secretary of State has said can only be withdrawn where there is substantial harm, which is a different test. And if it had been that the notice was confined and the burden is on the local planning authorities, not on us, if it was seeking only a particular advertisement or a particular category, then that is what the battleground is put on. But if you're seeking a notice that will apply to all of the matters set in the statute, you have to justify it. It's as simple as that. And it's no excuse. If it was the excuse then to say you can apply for planning permission, what's the point? You would just issue a discontinuance notice, gone, no right of appeal, no substantial harm, and you just say, well, you can apply for planning permission. Effectively, what my lord is putting to me is potentially, in my submission, if you're not doing an abuse of power, because the legislation gives, and it's out with, it's classic ultra vires, because it's out with the jurisdiction. And I'll come to it now. We look at the regulations and we see, so if we go to, if I can take your lordships to, if we start, obviously, I can deal with this very shortly, Regulation 3, and then we come on to Regulation 8. Appeal bundle, page 4. Sorry, authorities bundle, page 4. The difference also with advertisement control and wider planning is the limited factors that you can take into account. So Regulation 3, powers to be exercised in the interests of amenity and public safety. So that is different, and my Lord Justice Dove will be very aware, the wide range of material planning considerations that can be thrown into the pot when you're dealing with normal town and country planning. Here in this carved out mini jurisdiction of advertisement control, not only if it's immediately criminal, but the powers can only be exercised in the interests of amenity and public safety. And that is why, as well, the development plan we see at 31A, they are said to be a material consideration. So we're looking at just a material, insofar as they are material, and that is to the questions of amenity and public safety. And then you see, without prejudice to the generality, it expands on the factors that are considered relevant, but it's not a closed list to what you would have in amenity. So, and then that's regulation 3. Deemed consent is regulation 6 on the next page. Subject to regulation 7 and 8, and we'll look at 8 in a moment. And the case of special control also to regulation 21. So just pausing there, special control is where you can issue, and there's a whole procedure and possibility of challenging, where you designate particular areas as subject to particular control. So various deemed classes don't apply, but that's a special order that's made, doesn't arise here. But of course, if this was the intention of the planning authority, if it wanted the area around Manchester Piccadilly to be one where as a block it was subject to special control, then there's, your lordships can see regulation 21, page 15, provides for a procedure for doing that. So then we have the deemed consent. There are standard conditions that don't really are not subject to this appeal, and then there's another question on the limitations that apply other than to class 12. So then regulation 8, which is obviously the principal subject, that provides a power for the local planning authority may, if it's satisfied, and it's, again, I obviously emphasize necessary. So it's not just an exercise, you've got to be satisfied that it's necessary to remedy a substantial injury to the amenity of the locality and then a danger to members of the public. That's usually highways, doesn't apply for the purposes of this case. And so we emphasize necessary, need to remedy a substantial injury to the amenity. And then we say it's clear how the structure works in that it acknowledges there's a difference from a particular advertisement or the use of a particular site for the display of advertisements for which there is deemed consent. So as we can see from Putney Bridge, you can, within that, as the parties, well, they agreed, and the notice was issued in respect of a particular deemed class. And we'll look at Putney Bridge a bit later. But the battleground was all just battling over the withdrawal of that deemed class. But it's important to see service requiring discontinuance of the display of a particular advertisement for which there is deemed consent, or the use of a particular site for the display of advertisements for which there is deemed consent. We accept that in B you could cut down that and specify, as they did in Putney Bridge, certain categories. But
can I just be clear about
yes.
one thing? Regulation 6 talks about deemed consent for the display of an advertisement.
Yes.
It doesn't talk about deemed consent for the use of a particular site.
No, that's right.
Nevertheless, 8B must be contemplating that deemed consent may be given under Regulation 6 for a site rather than a particular advertisement.
Yes,
It may
well,
be very obvious, but I just wanted to understand it.
yeah, I should explain that unless there is some special control, every piece of land has theoretically deemed consent for all those categories. We'll have a quick look at them. So it isn't that any further decision is made to say this site has deemed consent for these categories. It's a bit like limited development in this respect. Across the land, on the face of it, every site has deemed consent. I say that as a general.
Well, in every site.
I'm not sure that is a direct,
No.
in fairness, because, in fairness to you, permitted development rights are essentially arise from the use of the land,
Yes.
by and large, or the nature of the person or institution who are going about to do the work.
Yes.
So, statutory undertakers have certain permitted development rights to dig holes and do what they need to do, put up telegraph poles,
Yes.
as they did outside my house.
Yeah.
Not that I bear a grudge, obviously. They are specific in that sense, but I think my Lord's point is, and your response is related to just land generally having that.
Yes. My Lord is quite right. Permitted, and this is why, while there's certain analogies to be drawn with permitted development, as I was explaining, but there are big differences because.
I think if you're trying to answer my question, you're giving much more detail than I need.
Yeah.
There must be a one-sentence answer.
Yes.
Where do you get deemed consent for a site?
It's just there. It's for all sites.
Well, that's as a matter of general law, is it?
General law prescribed by the Secretary of State under the statutory instrument that gives deemed consent.
This is the statutory instrument that gives
Yes.
deemed consent.
That's right.
But where do I find a bit about deemed consent for a site?
So what you find is Regulation 6 says the
Yeah.
categories that have deemed consent. So
But that's deemed consent for the display of an advertisement.
yes, and then you
Page 68.
68. Thank you, my lord. You have
If my lord knows the answer, he will tell it to me, and we won't waste time in court. But I just wanted to somewhere we will find a provision.
Well, I think this regime operates on the basis of types of advert,
yes,
and all land has the opportunity to have deemed consent to the various types of advert that are set out in Schedule 3.
Yeah, well, that's good enough for me.
that's correct.
Thank you.
Just for the sake of completeness, and it's not that it doesn't, but in Regulation 6A, they are, with the exception of, and we don't need to look at B, they are subject to a standard condition. So, for example, if the land and an advertisement within that category was a highway safety threat, it wouldn't
Do
comply.
I really need these kinds of details? If you're answering my question,
Yes,
I
no,
don't
okay.
need any of this.
Yeah. Okay.
Thank you.
No. So the answer is yes to all land,
Okay,
which is
thanks.
different to permitted
Yep.
development, as my lord said. So the Regulation 8 deemed consent. Yes. If we go back to Regulation 8, a discontinuance notice shall be served on the advertiser, shall specify an advertisement, or the case may be the site to which the notice relates. So I just rely also, as the case may be, again reflecting that two-tier choice, and then it specifies the period for which the display, or again the use of the site. Now the regulations aren't always consistent in their use of language, but in my submission, our submission, giving its proper purposive and ordinary meaning, you've got, again, the continuation of that distinction between a discontinuous notice, which is against the display of an advertisement, or the use of the site, generically, for the display of advertisements which would otherwise have deemed consent. And then C shall specify the period at which the display or the use shall be discontinued. And then D shall contain a statement shall, and all of this we say is mandatory, the use of the word shall, contain a statement of reasons why the local planning authority considers that a substantial amenity to the a locality or a danger to members, as a case may be, is being caused, and 2, considers it necessary to serve the notice, and then it includes the name of the people. So we submit to your lordships that it's very clear when you look at the structure of what we say is a draconian power with withdrawing rights, that it has 2 types, effectively, of broad categories of discontinuance notice. A 1A specific advertisement, a Reg 1A use of the site for the display of advertisements, and as we say, Putney Bridge shows you could do a sort of category of deemed class. But again, as you'll see in Putney Bridge, the argument was all about that category. It wasn't about other categories. As I've said, contrast to Regulation 3, we just flip back to Regulation 3. The test is higher. So Regulation 3, the powers are just in the interest of amenity and public safety, but to withdraw this right, the test is substantial harm. And that was recognised in Putney Bridge, as we see that it's a higher test. The statement of reasons here is an express statutory duty, and we say that's reflective of the draconian nature. 1, it's taking away a right, and secondly, unlike ordinary planning where rights are taken away, this makes something, otherwise the display then goes from not even being permitted to a criminal offence. So, and we don't believe it was ever disputed by the Secretary of State, or indeed now. The burden is clearly on the decision maker to demonstrate necessity. It's plainly set out there. They've got to consider it's necessary for the reasons that I've just taken you, and also to give their reasons to satisfy that necessity test.
Can I understand the significance of that in this case? You're not saying, or you're not saying at this stage, that the decision notice is invalid because it didn't give reasons.
It gave reasons, but they didn't. We say the decision notice should have been quashed because it withdrew deemed consent without demonstrating in the notice why it was necessary to do it. The only thing it sought to do was demonstrate why the particular display should be withdrawn.
So I'm not sure I'd followed this. So it's within the grounds of appeal that a particular complaint is that the decision notice itself did not comply with 3D, 83D.
It didn't comply, and then as a result, when the Secretary of State considered whether it should have been quashed, now it may be, and it never came up because the local planning authorities we've seen never then sought to justify it. So no argument came up saying, well, can you ex post facto now amend, and the inspector has the power to vary the notice. So the case isn't that. The case is from day one, the notice and the case presented did not justify the scope of the notice. So it's not just even before the inspector. The notice was not, let's say, valid, but there was no attempt to correct that, even if there was powers so to do, by submitting evidence that the other categories of deemed consent would cause substantial harm. Before the inspector, and when we come to the inspector's decision, the inspector does not address any of the other categories.
Well, I entirely followed that point.
Yes.
I hadn't followed that you were pinning your colours to the mast of the notice not containing a sufficient statement of reasons.
Well, I'm not pinning my colours to the mast. It's part of, in that sense, because the way it developed, that point never got addressed by the inspector either, so we just attack that. But and it never got into whether in this particular fact the inspector could have varied the notice if the local planning authority in its statement of case had said, I know the notice doesn't say anything about car parking notices and other deemed consent, but we say these notices are cause substantial harm, or any of these categories would cause substantial harm, because this site is so sensitive that therefore the site cannot be used at all for the display of any of these categories. That's our case, but it does go right, and I'll come through and show you, this whole thing is just carried through, and notwithstanding the planning consultant, actually my clients kept flagging it up and saying, what is your case on these points? Came their case never, and we'll come on to see it. So we're not saying that it's not a case that developed because of the way it developed. Our case is the notice was flawed, it was never corrected at appeal, and the inspector's decision is wrong, and the court below's decision is wrong on that.
That's why it's a narrow point.
Yes.
Yeah.
But I'm not saying the notice was good. The notice was bad because of that reason that carried on and was never addressed. If I can show it in my submission, we think it's quite simple. It may not be attractive, but it's very straightforward, and it was raised before the planning authority and the inspector. If you're going to uphold a notice that's so draconian, so wide, you've got to do what the regulations tell you, and the guidance as well as I'll just take your lordships to. And it's not, just to say, it is not for the appellant, and I'll come on to deal with it later, to cut down the notice. We're not the person, it's not our notice, we're not satisfying the burden. It's someone coming forward with a case saying, give us all these powers, and we say they don't justify them all. And if they don't, and the notice is as a whole and can't be, and wasn't corrected, the whole notice, we say, the decision fails, it goes back to the Secretary of State for it to be reconsidered. So the forum for debating the notice is the Secretary of State rather than the High Court. So can I take your lordships, please, then just to the guidance, which we will find appeal the authorities bundle 83, 84. I was going to go to 84, but I'll go first to 83. So, and it's quoted in our skeleton. So this is the Secretary of State's guidance. It's really if I just take you to the second paragraph first, it's just by way of background. When using this power against a site, local planning authorities need to define precisely the site or part of the site to which discontinuance relates. Now, I know that's dealing with the part of the site, but it emphasises, again, in my submission, the need for precision. Then, just by way of background, again, prior to serving a discontinuance notice, a local plan would need to consider whether a modified display would be acceptable, and if so, the authority can discuss this with displaying the advertisement. So if you're upset about the particularities of the advertisement's digital nature or whatever, but if you're saying irredentously, this site cannot be used for the display of deemed consent advertisements, that's a different matter. And then it says who it should be served on, and then it's more what must be stated in a discontinuous notice. Again, the guidance is expressed in mandatory terms. It provides specific details in summary, and it sets out the advertisement or advertisement site whose display or use is to stop. The reasons why the display or use must stop. Statement of reasons, and then when we say how much detail in the reasons, Regulation 8, according to the Secretary of State, requires a statement of the reasons for taking discontinuance aid. This must explain why the local planning authority considers that substantial injury to the amenity of the locality, etc., as the case may be, has been caused, and why it considers it necessary to serve the notice. And it says the reasons given should be specific to the light and leave the person displaying the advertisement in no doubt, and we'll see how that manifests itself, about exactly what makes the display unacceptable to the local planning authority. So if the notice specifies a particular advertisement, the statement should specifically address the particular advertisement. If the notice refers to the use of the site, the statement must explain why the use of the site as a whole for the display of advertisements should cease. So that is the Secretary of State's guidance, which we say is a correct statement of the law and was not followed in this case. So if I can leave then the regulations and the guidance and go to the notice and the background of it, if you take the supplementary bundle, and I'm not going to go into all the categories of deemed consent that are caught, but just staying with the practicalities, if we go to supplementary bundle 78. Sorry, it's slightly different pagination now. I'm looking at the wrong. Yeah, so on the classic court bundling, we've the bottom right is 75. You can see one of the Eurostar car park sites there, signs, and if your lordships go to 73, probably less clear. You can see the other directional signs, particularly to the that in relation to the car park. So they're a form of deemed consent, one of the categories of deemed consent, and yet they never form, for example, even though they're displaying, they never form any part of the council's reasons for issuing the notice, their case, and we'll come on to look at the case in a moment, and they make and indeed the inspector's reasoning, but they're caught by the scope of the notice, which takes away all the deemed.
We haven't seen the notice yet, but you're saying so.
I'm going to take you to the notice almost next. Just before we go, just very quickly, just looking at some views. 198. Supplementary bundle. Yeah, you can see 198. You've got the car park signs there. Car park, £8.50 all day. Bad price.
And,
Sorry, 198.
Yes, 198.
The bottom right-hand one.
If your lordships look, bottom right, view B along Addington Street and view A along Addington Street, and well, actually all of them. View A.
I see. I can't.
It's those yellow ones.
and for completeness, can you immediately say which class we're in Schedule 3 terms?
Yeah, we're in. We're either Class 6, advertisement on the forecourt of a business premises, because the car park is a business premises, or Class 13, have been a display without express consent for longer than 10 years, which is Class 13.
So just help me on which. Conveniently, we got the map on the facing page.
Yes.
I can see Addington Street, and the sites of those two photos are helpfully shown. Where's Miller Street, which we saw referred to in the earlier photo?
I'll ask for instruction. Oh yes. No, you can ignore Miller Street and that.
Well, that's what I thought. Miller Street
Yeah.
was a separate.
Yes, sorry, my mistake.
Well, it
yes.
was a bit unhelpful.
No, I
was confused. I
apologise.
thought I didn't know enough about it.
No,
so
I
we can
apologise.
ignore Miller Street.
Just for my purposes, these ones are good enough. Sorry, I apologise.
So these are the car park advertisements
Yes.
which you say are caught, not the
Yes.
Miller Street one. Okay, thank you.
Well, we won that. My client.
Well, I dare say, but the point is they're
yeah.
nothing to do with this appeal.
Correct.
Yeah, okay.
And apologies.
And just another red herring for a moment. If I look at the bottom right-hand corner on 198,
Yes.
there are two signs. They possibly have different functions, do they? One has an arrow on it, which might tell you where to go, and the other doesn't, I think.
The other one tells you the price.
The other tells you the price. That's presumably obviously an advertisement.
Yes, but
If you have something with an arrow, is that different or is that the
Yeah, that's
same?
an advertisement as well. The definition of advertisements, and it may come before the courts with all the controversy, but I'll give you an example which has been overlooked, and the controversy at the moment about putting the flag of St George and Union flag on lampposts. That ordinarily, those flags, which we wouldn't normally think of as advertisements, are classed as advertisements, but had deemed consent, subject to the permission, the owner's permission, which they don't have, and anyway, that's a beside point. But I just give that an example of something that in ordinary language we wouldn't think of as an advertisement. Even the hoarding, not to get too technical, even if it had nothing on it, is an advertisement.
And if within your car park you didn't have anything saying car park, you just had an arrow to point you around the corner,
That would be an advertisement
that's
as well.
an advertisement as well.
Well, it's deliberately drawn
Widely.
widely to avoid to catch people who are fly posting, all of that sort of activity is caught,
Yes.
and that may explain why it has a criminal sanction, because unlike an enforcement notice, which obviously has a landowner to whom or a land occupier to whom it can be directed, the problem with fly posting is that it requires somebody to be identified in order to enforce against it in that sense.
Yes, but there's also separate legislation about fly posting as well, my lord. I would not accept that if it's been put that the whole purpose of the advertisement and criminality is about fly posting, because it is widely drawn. But what we've already looked at the regulations and things, it is expressly done to capture as wide as possible the whole area of advertisements. Not just fly posting. That's why if you look at the requirement, the advertiser, the owner can be liable. Also, the person whose goods are displayed on the advertisement. So that gives local planning authorities, if they want to, you've got Heineken beer or some, I'm not suggesting anything against Heineken beer, but a well-known brand, you could then write to the director and say, here's a picture, get something done. And that when I on the other side,
We're a long way from the point, aren't we?
yeah, it's the point is that I'm just giving this as an example that falls into two categories of deemed consent that have been withdrawn.
Yes. But just one point that did come up by a side wind, which puzzled me as not being as familiar with this area. So an empty hoarding is an advertisement.
Yes.
Okay, that's fine.
Yeah.
So compliance
I
with
can
the
take
notice
you
will require not just not displaying anything on it, but it will require taking down the structure.
Yes, but
Yeah, okay,
the
that's
removal
fine.
of the advertisement, of course, is to catch the hoarding staying up.
Well,
and
don't
then it
again.
becomes a target
You're
for fly
answering
posting.
more detail than I
No.
needed.
It's cool. We can go to the definition of advertisement if it's
If
disputed.
it's common
but-
ground, don't do it for
Yeah.
me.
No.
Thank you.
It's a wide definition. And then if the discontinuance notice is in a number of places. I just want to take it in just for convenience because I want to go to the covering letter as well. Supplementary bundle 85, 86. So discontinuance notice is at 85, covering letter is at 84. Go to the discontinuance notice, and we see why it caused confusion. It's you're using for the display of advertisements the site described in the first schedule, which deem consent Manchester City Council local planning for the reasons stated in the second below, it's necessary to require the use of the site for the display of advertisement to
Sorry, where are you reading from?
the discontinuance notice, page
Yes, but
85.
which paragraph?
The first two.
You're on paragraph
1
2.
and then 2.
You were just reading from paragraph 2.
Yes.
Paragraph 2. Thank you. Sorry.
And then under the powers conferred by Regulation 8, so it just says Regulation 8, the Council requires you to discontinue the use of the site for the displays of advertisements, and then it gives the period. And then first schedule, it identifies the advertisement that's in place, and this is LED, so it's the Manchester Cavernous shown outlined yellow on the attached plan, and it gives the site and the boundary edge, the advertisement site shown edged in red. Then the second schedule, which is what it fights against, is the use of the site for the display of an advertisement is considered to cause substantial injury, etc., contrary to the overall aims of regeneration. The advertisement is on the advertisement main arterial and highly visible due to its dominating size of this crossroad, and fails to make a positive contribution to the wider generation strategy of the area.
Sorry, just one moment. I just want you to understand the first schedule. So that first schedule purports to be the description of a site. That's paragraph 1.
The advertisement.
No, you're using for the display of advertisements the site described in the first.
Oh, sorry,
schedule.
paragraph 1. Yes. Yeah. Yes.
So the site.
Yes.
The first schedule starts with the words the LED advertisement display.
Yes.
Referred to as the Manchester Canvas.
Yeah.
The Manchester Canvas isn't a particular advertisement. That's effectively the name of the hoarding, isn't it?
Yes. Yeah.
Yes. And then it shows you where it is. And the last line uses the phrase the advertisement site. So this is the description of a site. It's not a description of a particular advertisement, which it should be. I just wanted to be sure I'd understood that.
Yes.
Okay, thank you.
So the notice, and as the inspector found, this is a notice that is directed against the display and use of the site, the display of advertisement. It's not
the site presumably is the site as defined in the red line plan, which
Yes.
is attached to the notice.
Yes.
And is that the totality of the car park on the red line plan?
Well, are we on page 88?
Yeah.
Yeah.
That has red lining. That seems to be where the hoarding is.
It is.
The
But
parcel of land which is used as the car park is that between the main road, Rochdale Street, and the hotel, isn't it?
And just to, give you two questions to answer instead of one. The parcel outlined in red is only the site of that particular Manchester Canvas. It's not the site of the two car park photos, which are on Addington Street. Isn't that right?
yeah, it's yeah. It doesn't include all of the car park, but it's less clear whether it includes. If you look page 87, and it's less clear, you can see one of the car park advertisements to the left, close
I
to.
can't, but I'll look
It's
at it.
Yeah. Well, to the there
Oh,
are,
I see, yes.
yeah, which would seem, and this is the
right angles. Isn't it?
yeah, it's my
But
looking
the notice wouldn't prevent you moving those signs a little further away from the site as identified in the red line plan, would it?
No, I mean,
And speaking to myself, can I just? It's not even clear to me at the moment that they do fall within the red arrow. I would have thought that you'd have to be on the site to be absolutely sure that the two car park ads start just southeast of the of the corner of the site.
I mean, well, looking at the view we took was, at least that one was included within the site. The point, though, still remains that you would not be able to use that site, that red site, for the display of any of the deemed class advertisements. So, if, for example, just to
yes, I'm sorry, but I just want to be clear about this. I've absolutely understood, as I read the papers, your point about this big site, which I now remind myself is called the Manchester Canvas,
Yes.
the red line site. But you were making a point as you went along
Yes.
about won't just affect these, it'll also affect the two car park signs. How silly is that?
Yeah.
But in fact, as far as I'm not at the moment persuaded that that side point of yours is a good one
well,
on the facts.
okay. Well, my lord, we don't have mathematical measurements, so it's a point I just took orally on the site, looking at the position and looking at the red line. If you look at the
I
two,
don't remember it being a point taken in front of the inspector, but perhaps it was.
no,
The inspector would know.
no. I mean,
Yes.
no. Look, it's a point I raised. Our case doesn't depend on that point.
Okay, well then I shall cite that point.
But hypothetically, my answer to my Lord Justice Stuff's point about if it was in the site, and I know that these people were treated not in the site, just move it. That, and my point, that's not the point. I mean, you've got our fundamental point. Our point is, if you're extinguishing these rights, you have to justify them.
Yeah.
And
No, for you to say how to do your case, but that's the point to focus on,
Yes.
rather than
And-
making bad points on the side.
Yeah,
Sorry, that sounds
I
ruder
agree
than I mean, but
no.
it's a distraction.
It's a distraction.
Yeah.
I mean, the point I'm just using for is, and it's not run, in fairness, it's not a point that's taken against, oh, these are all points that, these are never rights that ever be used on this site. Well, of course, one, that's not the test, but in any event, these car parking sites, if they were, they wouldn't be able to be put on the site, for example. So I'm just giving those for a slightly different point.
It's not at all obvious you would need to put any directional sign in the position of this hoarding.
Well, I don't know, and I don't know what the ultimate situation would be in terms of how the configuration and other things for Manchester Piccadilly will work, because that was part of the local planning authority's case against the particular advertisement, that their plans for that area had changed, and there were all these plans coming forward. That happening, and it is an issue of the position of the car park there. If things are moved, this is just, one would have to leave open, my clients would want to leave open the right that if the configurations change, they would be allowed to move their signs to that point. I'm not saying there are any there are general proposals to change the area which the council relied on. But our fundamental point is, I think your lordship's got the point. The case that was advanced is, it refers only to the single advert, and the reasons given are only specific to the single advertisement display, and that's a justification. It doesn't even mention a justification as to why it follows that the whole site cannot be used for the display of advertisements.
Well, but this advertisement occupies effectively the whole site.
Yes,
The display does.
Yes,
So,
but it.
okay, well, we haven't even read the justification yet, so
Well, the justification is there on.
That's the
the
second.
second schedule.
Yeah, it's on the second page. I can leave your lordships to. I didn't, unless your lordship want me to
And
read it out.
the second part fell away.
Yeah, that fell
traffic
away.
bit.
Yeah, and it applied specifically to the advertisement in question because of its digital nature. And the first bit is again specific to the advertisement. Its dominating size, and its failure to make a positive contribution. I mean, whether that's the right test, but that's not before your court, is another matter. We say it's clear that the only justification is given in this notice is the specific advertisement.
Yes, I see. Sorry, to a non-specialist, that seems a bit odd. I now understand. By where you mean a specific advertisement, you effectively mean the specific hoarding.
Yes.
Your point is that what if you'd want to put up a little hoarding there?
Yes.
6 feet high.
Yeah. Or one within deemed consent that would be smaller. Yeah. And that's gone, including, for example, wherever they were.
I've got the point now.
Yeah.
Thank you.
So for example, my client would otherwise be entitled to advertise more widely what good value the car park is. £8.50 apparently, if I could make it out. But, or whatever. But on that site, since they've lost the big hoarding. So, but this notice stops it. If we go then to the statement of can I just take you, before we leave the notice, paragraph 84, page 84. Now this is the letter accompanying the discontinuance notice, and it explains from Manchester City Council, I'm reading page 84 of the first paragraph, has issued a discontinuance notice relating to an advertisement. This is what they say on the above side, and I now serve you a copy of the notice of person having right. I mean, I understand this is the covering letter, and you look at the notice, but it is then reflected in the way in which the city justify their case in that covering letter. Although the notice, in fact, applies to the site, the letter in our submission is clearly focused on the advertisement being displayed. I know it's just a letter, so I don't rest my case entirely at all on that. But when I take your lordships then to see how it progressed, one sees it's consistent entirely with the case that was put before the inspector. And if we go then 187, just staying with Manchester City Council, the Planning Authority, to their statement of case. So this is in response. I was taking it slightly out of order, but just because this will be in response to my client's appeal. There are a number of issues, and can I take lordships to, it begins 186 under the heading substantial injury. We don't need to do with 5.1, which quotes High Court authority, and Putney Bridge we can look at in due course, deals with what the test is. 5.2, the City Council, this is page 187, as local planning authority, considers that the advertisement holdings at the appeal site do present a substantial injury to the amenity of each of these areas. Bearing in mind this is the other appeal as well on the other side, so that's why it's in the plural. Then we see throughout, with dealing with other arguments, just briefly 5.4, dealing with the fact that it's another issue, but about whether there's any material change in circumstances, but the focus again is on the advertisement. And as such, as assessment to the positive contribution, the advertisement site must be an appropriate means of satisfying the council's burden. Now, I'm pausing there, it's not before your lordship, but I don't accept the need for a positive contribution is the right test. What I'm highlighting is it's a recognition, it's the council's burden.
I'm sorry, I've got lost. Which paragraph are you in?
I'm sorry, 5.4.
5.4, thanks.
It's just the way the count. As such, it's the last sentence. As such, an assessment as to the positive contribution of the advertisement site must be an appropriate means of satisfying, namely that there is a substantial injury, this when reviewed against the backdrop of the wider generation. And then we look at 5.6, which again, it's plural because it's talking about more the two sites. It talks about each of the advertisements are overly large, visually dominant, having a detrimental effect. Then 5.7, the eye is drawn to each of the displays, and that's Miller Street A, which we are not concerned with. And then 5.10 talks about the character saying it's substantially different now. The council, this is on both sides, the council has therefore based its assessment on the character of the area at the present time on the basis considering, and this is what we emphasise, the existing advertisements to cause substantial injury.
And just help me, not knowing how this works, this is the council's statement of case.
Yes.
You've already appealed by this stage.
So we put in a statement of case, which I'll take your lordships
Yes.
to. I'm just continuing with the council.
Yes.
Because there's also, it conveniently refers to earlier correspondence, but I just wanted to take your lordships to how the council. The council acknowledged that in viewing of the appeal sites, and this is why, in answer to my lord's question, although it's a bad point looking at it, I was of the view that it was common ground that they were in the appeal sites. That in viewing each of the appeal sites, that there are other directional signs positioned in each.
So where are you reading from?
5.1, 5.11. I mean, we may not. It may, the government.
I see. Okay. Well, I remain to be persuaded that's right, but it may be they were there. Okay.
Yeah, and that's partly what emboldened me on the submission. And then what they then say is, oh, these directional evidence are deemed common feature of primary roads serve an essential purpose and part of the established fabric. The car park, way finding, pricing, and rule of advertisement will form part of a separate investigation on each site, and as such, they've disregarded their impact when assessing the immunity of the appeal sites. So I understood that paragraph of their case to say these signs that I took are on, or at least some of these directional sites are on the appeal sites, and we've disregarded them. But yet they're still withdrawing consent from them. So, I mean, I haven't measured it off, but my submission is I'm entitled before this court to work on the basis that was before the inspector and the council that those directional signs were on site.
Okay, well, I was obviously over hasty at the moment. I'm not persuaded, but
yeah, but
most of the people in court have been involved in this case for longer than.
I wasn't in the appeal hearing.
One would have to go and look at the site at the moment.
Yes.
I'm not persuaded, but the council thought so. I've obviously got to think again.
Well, we're always.
But in a sense, none of this really matters. Because
No,
the point you made earlier, whether they're within the site or not, they're simply, you're using them as an example of the kind of very different kind of advertisement in the sense of hoarding, very different kind of hoarding that could be put up, and the discontinuance of permission to use which has not been justified.
No.
Well, I've got the point.
Yes, and I just go there because whether it's on site or not, they're expressly saying they haven't looked at it.
Well,
yeah. Okay. I'll move. So if I can then take I think in fairness I should go then, just so your lordships have got to the appellant's first statement of case, and one finds that at the beginning of tab 1 and page 3, and I just take it briefly, and for convenience, although the correspondence is set out, can I just take by way of the background? So this was put in an appeal, and then I've taken you to the local authorities' response, and then I'm going to take you just finally the rebuttals each side had. But here is the appeal statement, page 7, 2.6. This is prepared by the appellant's planning consultant, Mrs. Jones, no relation to me, as far as I'm aware, and sets out, as both notices you'll see, she says there's uncertainty also with this notice with respect to whether it's concerned, and I'm reading from the specific advertisement referred to in the first schedule, the removal of all...
But where are you reading from? I thought you were reading from 2.6.
2.6, the quoted paragraph she quotes from the letter she wrote.
So you're starting on the second line of the quote. There is uncertainty or something.
Correct.
Yes, I see. Okay, yep, thank you.
And referred to the first, or the removal of all deemed consent rights with respect to the site editing red. Again, notice currently appears to be flawed either way. Furthermore, again, the council's statement of facts with respect to amenity issues is very brief and vague, with no comprehensive justification to demonstrate why the advertisement use of the land display causes substantial harm. And then she deals with public safety there.
Incidentally, everyone keeps saying substantial harm. The phrase is substantial injury, isn't it?
Substantial injury,
So
yes.
you got that wrong.
Yeah. She does return to, and then 2.7, she relates to the communication which she had before the appeal, the response, and it's 2.7, and I'm reading from when it says, the second schedule clearly sets that the advertisement is considered to cause substantial injury to the amenity of the
So
locality.
I'm being very slow. Where does it say the second schedule clearly states?
It's about 8 lines down.
Okay, thank you. I found it now. Yeah, thank you.
He then sets out Regulation 8.3, and then at the bottom it's clear both notices contain a statement of reasons. If there is a dispute over this justification, this is a matter to be considered by your client in event of a repeal. There's no requirement, he says, in this to be excessive in content, but only should contain the reasons why the local planning authority considers substantial injury to the amenity of the locality or danger to the members of the public. He's just taken that quotation without referring it to advertisement or site for the display, and he just asserts that that satisfies the requirement. Well, obviously, we say no, it doesn't, because it doesn't say anything about the site beyond the one advertisement. 2.8's the last, and this is all in the, it's 2.8, I might if you go to 2.10. He says, Mr. Jones's interpretation, this is the statement of case, of Mr. Roche, who's the local authority planning officer, is concerned with the that DN2 is concerned with the use. So that's this notice, the subject land for the display of advertisements which enjoy deemed consent, and not solely the display which is currently on the site. However, she says, if her interpretation is incorrect, then the appellant reserves the right to make further representation. So what she's saying is, well, this is just what she said. Her understanding was that he was basically saying this is about the advertisement, not the site. But she says if it's wrong, she'd want to make further representation once the council's full case is known. Because, I mean, obviously, it's for the council to justify why they're withdrawing these other consents. They haven't said any reason. So the appellant's in this position where there is nothing for them to go back on.
So I probably wasn't listening carefully. So
Yeah.
she says she understands this notice to relate to the use of the land, not to be limited to this advertisement.
No, she says, at the top, she says, her interpretation of his response, which I've just taken you to, is that the notice is concerned with the use of the subject display of the land, which enjoins set, and not solely for the display which currently is on the site. Sorry, it's my...
No, I follow that. So when she then says, well, if her interpretation is wrong, she reserves the right, she's dealing with a different scenario.
Yes.
So here she is addressing the scenario which has been followed through, which is, it relates to all advertisements, not just this one.
Yes, but she doesn't know what their case is. She says if she's correct with the interpretation, this means seeks the cessation of the use of for any advertisement which enjoys deemed consent other than Class 12 Schedule 3, which is the one to which apply. Those advertisements would appear to be relevant in this case fall within the following categories. So I've only picked out one or two, but she's picked out in the statement of case the categories. Conceivably, there are some that I'd accept would be far, that wouldn't apply. But she's identified before the inspector at the beginning of the appeal those categories.
She isn't saying she doesn't know what their case is. She's saying, look, if I've understood their case correctly, it applies not just to this advertisement, but all these other categories.
Yes, and she's saying they haven't said anything about them, and she's highlighting that because in her correspondence, which I read to you, before she did her statement and case, she said it's brief and vague. This is back on paragraph page 7, and you haven't said anything about why the site as opposed to the... So she put that to the officer. He then just comes back and we've seen what he says, but he doesn't put any explanation because she then has to put the appeal in before the council. So she's putting it in
But if we go back to page 89 of the bundle,
yes,
a piece of unexplained trivia. Because page 89 is an annex to the decision notice, the discontinuance notice, and it advises you or your client of the right to appeal and refers to various regulations, and presumably there are also regulations pertaining to the procedure for written representations on an appeal of this kind, which we don't currently have. But it says that the person appealing, I'm in the second paragraph, must send with the notice of appeal a copy of each of the following documents, the notice, any notice of variation.
Yeah.
Now, I'm not aware that there was any
No,
notice
no.
of variation in this case,
No.
so it wasn't put as part of the appeal that the discontinuance notice should be varied in this respect or that respect. For instance, in relation to deemed consents.
Yeah, the position was an appeal against, I mean, we're not appealing on this aspect, but on the merits finding of the advertisement, but also saying that the notice isn't justified, well, I'm taking you through it, because the council hasn't justified the scope of the notice. There is no obligation on us.
Well, that's the point.
That doesn't create an obligation.
It appears that the regulatory procedure incorporates provisions, and we don't have them. So this may be, the annex to the notice may be legally inaccurate, but it appears to suggest that part of the procedure does include that.
The inspector has a power.
No, the inspector has a power.
Yes.
But this is the procedure. So the procedure of invoking that power isn't that the inspector decides for himself, I'm going to exercise the power, so he might. It also includes the opportunity for the appellant to say, as with an enforcement notice, although the grounds of appeal in that respect are pretty specific and bespoke, we don't think the notice goes beyond that which is necessary to remedy the impact on amenity that the local authority are claiming.
But we're equally entitled to appeal against the notice as a whole, which we did. We appealed, and I haven't taken you to it because it's not relevant to this appeal, against the substantial harm for the advertisement in question, and part of our appeal also, although there was confusion, but we're saying, if we understand this correct, it's to say that the rest of the notice hasn't been justified. It is not, because you had the opportunity to apply to vary the notice, does not shift the burden.
Obviously the rules make it clear. Is a notice of variation something that comes from you, or is it something that comes from the planning authority?
Well, it's from the planning authority.
So this is contemplating that.
Yeah, we can't apply
Right.
and say we want it. We don't put a notice in. If you look at the notice of variation. If you just go to the, the notice of variation is from the local planning authority.
So this is it's contemplating a situation where there's been a discontinuance notice and then the planning authority has backed down or something to some extent.
Yes.
Varied what it was going to say.
It's Regulation 8.6. Yes, my lord. That's.
That's the power to withdraw it,
Yes.
or vary it
Yes.
in relation to the time period in which it might take effect.
Yes, and you can still then appeal it,
Yes.
and then you would then have to let the inspector know it's been varied, so he knows what he's dealing with.
Yes.
But it's not. I was a bit cross, but it's not, as I think your lordship may have thought, that we go along and say, here are variations. How about this?
We think the
Yes.
notice is
Yeah,
overreaches that which is necessary.
Yeah, we can't issue a variation notice, or But we can, as we did. It wasn't that we were silent about this point. You know, right from the appeal, my clients have been raising this point.
Sort of. I mean, you say, your planning consultant says, I understand this to relate to all advertisements, and actually that means it encompasses all these different categories.
Yes.
So did she go on to say, well, that can't be right, there's no justification shown for this, that or the other?
Let me take you to... so we then have the councils taking you to their statement of case, and then if I can take your lordships to... the council then put in their rebuttal to our case, which just momentarily lost. Sorry? So if we go, there's a rebuttal at final comments 203. So this is from the council. So this is after they've received.
203.
Yeah, this is 203. This is after they've received the statement of case from the appellant.
I'm sorry, I'm confused. I thought the very first document was the document at tab 1.
That's the first one from the appellant.
So then the local authority puts in the document at 176.
Yes.
Then is the next one the document at tab 3?
This is referring to the appellant's statement of case. So the council were given another opportunity because they put them in.
So the council has gone straight from the document at 176 to the document at 203 without anything in between. That seems a bit surprising.
It should be quite straightforward just to tell us the sequence of representation.
Yes, we've got a chronology.
Where is that?
Oh, the tabs are in chronological order.
Well, that doesn't quite make sense, does it? Because the tab 3 says March 2023, but the document you're showing us at page 203 is dated the 12th of April.
Yeah, it's repeated at tab 4.
So are we best ignoring 203 and going to tab 4?
Yes, they're the same document.
But
It's just
on
I
that-
marked up the other one. That's
No, I
it.
see that. But on that basis, there is an intervening document, which is the document at tab 3.
Tab 3, which is from my planning consultant, March 2023, and it's paragraph 1.2.
And here she is addressing the document at tab 2.
Yes.
So if we want to see what you had said about what the council had said, we want to look at that one.
Go to there, 1.2, begins statement of case document.
Which page?
249, my lord.
Right, thank you. What do you want to see in 1.2?
It's the last two sentences beginning with likewise the council within its statement of case. So it's about 8-9 lines up. Likewise the council.
Is she right to say the council in its statement of case provides no explanation or justification regarding the form of the respective discontinuance notices which have been drafted to remove all advertisements which enjoy the benefit of deemed consent from the subject sites?
That's correct.
If we look at the notice, I'm sure you're right, but just so that I can understand it, the notice isn't quite phrased that way. The notice, if we go back to 85, the notice starts by saying, para 1, you're using the site for advertisements for which you have deemed consent. Yeah?
Yes.
And that deemed consent continues the effect of the express consent given in whenever it was, which expired in 2021, and is for the same hoarding that we've got now, right?
Yes.
So turning that into factual situations, you're using it for the hoarding you've got there now, in respect of which you have deemed consent, right? That's one. That's just a factual recital. Two, they consider it necessary to require the use of the site for display of advertisements to be discontinued. So it's not just advertisements for which you have deemed consent. It's advertisements generally.
It's which is 8.1b.
And then acting under the powers conferred, this is the actual effective paragraph, requires you to discontinue the use of the site for the display of advertisements. So it's not just advertisements for which you have deemed consent. So it may not matter, but I just want to be accurate about this and understand it myself. Miss Jones twice uses the phrase in her correspondence, it's been drafted to remove all advertisements which enjoy the benefit of deemed consent, but it's all advertisements full stop. The current one has deemed consent, and but it's not about. Perhaps the point is that since it's discontinuance, it refers only to the existing state of affairs, and the existing state of affairs is a deemed consent one.
No.
Well, you tell me.
The position is under the regulations, and when we come to look at the decision letter, we see at paragraph 4 for your lordship's note that it's pretty clear how the inspector approached it. It's regulation. He says, despite the inelegant drafting, it's 8.1b, i.e., in respect of, quote, the use of a particular site for the display of advertisements for which there is deemed consent.
Yes, I see. So although what Ms. Jones says doesn't reflect exactly the language of the notice, it accurately reflects the substantive effect.
Correct.
Which therefore is and that's why you come back to say it's related to this particular hoarding.
I'm sorry, I don't understand. The notice effect is effectively to remove all deemed consent, which is from the site. Which
but
is
the only deemed consent relates to the existing hoarding.
No.
Why not?
All under the statute, the site has, as we explained before, deemed consent for the whole categories of consent. The reason this is a particular class...
I thought the way deemed consent worked was that you had express consent.
Yes.
And express consent will be for a particular hoarding.
Correct.
If you have deemed consent, doesn't that only still relate to the...
No.
Okay, I've got it.
Because the category that the particular advertisement was a class 12, and that's that particular category that your lordship indicates where you've had express consent and then that's finished, but there's no removal. But all the other categories that we've taken you to, and the ones that Mrs. Jones highlighted in her statement of case, run with the land. So the land has that deemed consent.
I see. It's really okay. Thank you. It goes back to my earlier thing I had to.
It goes back to your earlier question, Mark.
Yeah, okay. Well, again, I don't want to hold things up. Now I understand it. Right.
Page 203, just the note we come to, but paragraph 4 makes clear that certainly for before the inspector and the inspector approached it, that was the effect of the notice, that it is to remove the use of a particular site for display of advertisements for which there is deemed consent, and that is.
So just reverting to the chronology one moment. So we got to 1.2 at 249.
Yes. So I'm at 249, and it's. I can ask your lordships. I mean, maybe just to read from likewise the council within its statement of state, and she makes the point. No explanation, justification for the removal of all advertisements which enjoy the benefit of deemed consent from the subject sites, not just the displays the council document specifically refers to. And she puts it like this: these are fundamental issues which are not dealt with in the discontinuance notice. In the light of the council's statement of case, the appellant and his professional advisors have no further in-depth knowledge of the council's case with respect to these issues.
And did she also address 5.11 of the council's case, the one you were showing us talking about directional signs.
No, I don't
Yes,
believe
yes,
there's anything about that's them saying they didn't take it into account. So it's bound up in that, because her point is wider than the directional. So they're included. I mean, not specifically, they're included within the categories of deemed consent. The two categories that I indicated that directional sites came within were cited in her statement of case amongst others. And she's saying, and I submit this is the, you know, in a sense, the crux of the case. If you're removing these deemed categories, the legislation requires you and the guidance to give your reasons. And here we've got no reasons and indeed no evidence. It's never addressed.
So does that then take us to the document you wanted to go to some while ago, which is either at 203 or at tab 4?
I think we may have already done. Yeah, this is the. So this is the council's final word.
In response to the last document, presumably.
So it refers to the appellant's statement of case. I'm just checking. I think the appellant gets the last word. Oh, it is after. Yeah. So this is
I
after.
presume this is all prescribed in the regulations.
Yeah,
That we don't have. Yeah.
So and this is what I have. So it's after the document we've just seen, and in terms of discontinuance notice, it picks up the statement of case, refers to the drafting of the discontinuance notice and direction for the site. It says, well, we've used this precedent book.
So where are you reading from?
2.120, page 204.
You're reading from 2.3.
No, I was reading from 2.1.
No, you've read that already. I was just
Okay.
trying to find the precedence. You're on 2.3.
2.3 is the precedents they refer to. I mean, that's just published by some publishers. It's not an official precedence. They say at the bottom, the appellants are fully aware of the extent of the notice and were fully aware in earlier correspondence they are pursuing this action. So again, no answer to the question. Then the next paragraph, 2.5, the advertisement display at each appeal location is a structured display as described in the first schedule and outlined yellow on the photograph accompanying each notice. This is this cited in the location of which is shown by reference to plan edge red. There is no reference to any other advertisement structure in each notice. Again, it's not addressing the point.
Sorry, just for my note, what's the photo ENF on? What's the reference for that? Is that one of the ones we've
That's
seen?
the photo attached to the discontinuance.
Correct.
notice.
Yes,
I
a
see,
picture
yes.
of the
Thank you.
main
Yep.
hoarding.
Thank you, yes.
And without, I mean, I'm just taking your lordships to really to prove a negative rather than
Sorry.
Right.
This is a red herring again. So it's 2.4 saying, well, we don't think there is any other sign in the site.
No, it's just, well, I don't know what it's saying. It's just saying the advertisement display site at each appeal location is the structured display. If you remember at the earlier statement of case in respect to the directional signs, which I interpreted that paragraph,
Yes.
and I think is a fair reading, but your lordship for that, we're saying within the appeal site are directional sites,
Yes.
but we're not pursuing those.
Yeah, it does seem to me that there's a mismatch between that, which you showed us
Yes.
earlier, and what is said here.
Yeah.
I mean, just may not matter at the end of the day,
No.
but to me, the concept of a site, I wouldn't have thought that a particular hoarding is a site. You
It's
put
red
a
line.
hoarding, or in your technical language, an advertisement on a site.
Yeah.
So the way it's put here, if it matters, Mr. Dale Harris can explain later, but doesn't sound quite right.
No, I mean, obviously, unfortunately, we don't. Oh, whatever. We don't have anyone from the local planning authority. So
No.
Mr. Dale Harris doesn't represent.
No, I understand that.
He
of
would
course,
have
yes.
no. Well, I mean,
Well, he
give
may
his
have a view
interpretation.
about it all the same.
He can have a view,
He
but
didn't
it's no
draft it,
different
so I accept that.
to us. He doesn't have any.
Yes.
No.
Well, it may not matter, but
No, it
it's
may.
trying to-
The main point to going to this is that it's really that nowhere is the issues raised addressed, and so, at any justification why the notice applies to all deemed consent on the site. And just for your completeness, it doesn't. Paragraph page 210. I don't particularly want to go. 211 is they exhibited. This was from a Sweet Maxwell publication. I mean, I don't. I just don't know how dated it is. It's obviously post 2007. But anyway, this is not any Secretary of State guidance or anything like that. It's just published by Sweet and Maxwell. And the local authority's position says, well, we just copied that, and that's good enough. And anyway, so that's we say is the position. This is not a point that's only been taken at the High Court. Throughout and even before the appeal, it was flagged up. The planning authority has produced no evidence, and we submit it's a simple case of plainly on the law. It's irrational to find that they've discharged the burden. You can't say just because you prove part of something, the whole can then be granted. Move away from that. If I can just make some submissions on Putney Bridge, and your lordships find that in the appeal bundle at
authority bundle.
Authority bundle. I apologise. 142. Is a particular passage I want to here it is. So the situation there, the decision notice in that case, paragraph 2, if I go at 142, we have sidelined the scope of a decision notice which relates to a particular site rather than a particular advertisement, the interplay between deemed and express consent, and the extent to which planning hypothetical alternatives to the actual advertisements in place of him. So in this case, it's important to see what the court were considering. The decision notice there says what you're required to do, and this is 143, quoted in paragraph 6 of the judgment. Acting under the powers hereby conferred by regulation, the council hereby requires you to discontinue the use of the buildings for the display of illuminated advertisements falling within Class 12, Part 2 of Schedule 3 within a period of 4 weeks. So that's the class which our advertisement was also under, Class 12. But there the note...
Just remind me what Class 12 is.
Oh, sorry, we were Class 14, because they're illuminated. It's Class 12.
It was in a building, is that right? Advertisements in a building? I did look at this.
Yes.
Yes, different from yours.
Oh, yes, it's different.
Yeah.
Different. But and the notice is different as well.
Yeah.
Because the notice is applied. It doesn't arise in this case, but it's obviously accepted by the Court of Appeal that you can
Limit it to a class.
To a class. Okay. Yes. And then the main issue is whether continued use of the site with deemed consent would be substantially injurious to amenity. And then it says the test in regulation requires that there must be substantial injury to the amenity to locate. Danger of members of the public, there is no danger in this case, and then it highlights what the inspector says. And then is an appeal from Mr. Justice Ouseley, and he sets out the position there, and it was essentially focusing on whether the inspectors should consider that within that category of advertisements, I'm summarising it, within that category...
Where are you reading from there?
I'm
summarising.
I'm summarising the judgment of Mr. Justice Ouseley.
And that which paragraph 11, is that right?
Paragraph 11, yes, and then paragraph 12.
Yep, that's fine.
So, in essence, the issue, as I understand it to be, was taken first time in the court, that the inspector within that category, which the whole inquiry had focused on and which the notice should have considered within that category some lesser injurious advertisement. Now, one of the problems with that submission is that in that case, before the inspector, the parties had agreed as a matter of common ground that the particular advertisement on display could be treated as representative of the whole class. That's in essence what was. So then you can see why, coming before the Court of Appeal, having agreed that, a party then says, oh, well, the inspector should have thought another form of advertisement that nonetheless would come within that category could have been acceptable, when they had expressly agreed on that. So if one looks at paragraph 23 of the context of this deemed consent, having set out what, in more detail, what I've summarised, paragraph 23 at page 148, Mr. Justice Ouseley said, in my judgment, these assertions run the risk of significantly overstating the effect of all the decision noted was to bring an end the...
So where are you reading? You said 23?
Paragraph 23, page
that starts the only question in this application. Are you reading from further down 23? Or am I looking at the wrong place?
In my judgment, it must be 148. It's Mr. Justice...
148 of Lord Justice Coulson.
Oh, sorry, Lord Justice Coulson, sorry.
Yep.
Sorry, I thought you meant 23.
I apologise.
Yes, okay, thank you.
Right.
Yeah.
So, these assertions run the risk of significantly overstating the effect. All the decision notice did, in that case, was to bring an end the LPA's deemed consent to the illuminated advertisements on the site. That deemed consent was by very its nature general in scope. It existed only because the advertisements in question were inside the building. The decision notice did not prevent the building owner from making an application for express consent in relation to any advertisements in any specified form. So what they were saying there was in that case they had agreed first of all that the category was represented by the advertisement. The notice in this case did not extend to other deemed categories as we have in this case.
So the category was advertisements inside buildings.
Yes. And
not just illuminated advertisements, but any advertisement inside a building.
And they had agreed before the inspector that that particular advertisement could be treated as illustrative for the class for the purposes of their debate.
You said that, I'm sure it's right. Where do we actually find that?
Let me just give you the reference. Paragraph 24.
Of Lord Justice Coulson.
No, of Mr. Justice Ouseley, which is at page 146 at
second point is the local authority and the appellant were content to treat the existing advertisement as illustrative of the general issues that arose
Yeah.
from the illuminated advertisements, and their arguments from the general arose from their very different appraisals of the specific advertisements.
Is the word "the" there redundant? As illustrative of the general issues that arose from illuminated advertisements? Or does it mean the...
I think if the paragraph then reads on with the local authority's submission based upon
Yes, all.
them illustrating, that is to say, the illuminated illustrating how severe the problems of illuminated advertisements. By contrast, the appellant contended illustrating how attractive they were to the street.
But just to be clear,
Arose by any other name.
Exactly. Well, this is the thing.
But,
You know.
So the complaint is about illuminated advertisements, but this is going to catch all advertisements inside buildings.
Let me just double check before I answer. No, it's, if you look at the notice, my lord, 143, page 143, and para 6 of Mr. Justice Court.
No, I see. So it's not
only
merely
illuminated.
so it's applying to a category within a category.
Correct.
Yes, I see.
And the parties agreed, all those who just read out had different views, that this particular advertisement was illustrative of that category. And then some said it was beautiful, some said it wasn't, and the inspector was entitled to claim his own view.
So so the real dispute was the owner was saying, you have got to provide a justification for, and the inspector must consider, not just this illuminated advertisement, which may have been particularly bright or particularly garish or particularly what it was, but other possible illuminated,
I think that's right.
which may be less bright or less mobile or whatever.
The effect of what Lord Justice Coulson was saying was, not a matter for the inspector, but if you want to apply for one which you say is less overly large, dominant and incongruous, then it's open to you to make that application.
Yes, yes. But you see, the circumstances, even ignoring that point by Lord Justice Coulson, it was a bad, I would say respectfully, a bad point of appeal in any event, because the notice specifically dealt with a category within a category, illuminated advertisements. They agreed before the inspector that for the purposes of debating what it would look like, the current one was illustrative, and the only difference between them was subjective. I think it looks nice. I'm simplifying a bit. Someone at the local authority saying, I think it doesn't. So that was the basis. Then to appeal and say the inspector of his own batch should have gone against what was before him effectively, and then thought, well, I could have had a less illuminated. This isn't actually as reflective as it could be, or it isn't.
Can I just be clear on one point? Do you accept that paragraph 23 of Lord Justice Coulson contemplates that it is possible to apply for express consent in relation to an illuminated advertisement inside the building?
Oh, of course it is.
Yes.
When the deemed consent is withdrawn, the
You
only
can
way...
still apply. It isn't. There's some
You're not
kind of issue
prohibited.
estoppel as to.
But the problem which I touched on before when I was answering a question from my Lord Justice Dove with permitted development rights is this. This notice is a finding by the Secretary of State through his inspector that the display of all deemed categories of advertisement on this site cause substantial injury to amenity. And whilst we can then apply for consent, we're not stopped. The balance of the Secretary of State's finding and the principle of consistency of decision making, I don't think any of these principles are in dispute. And as I said before, there's case authority as well, the High Court to say that, you know, the Secretary of State's decision is of a higher level than a past decision of the planning authority itself, has found that all displays of advertisements are with deemed consent on this site cause substantial harm, because that's the basis on which the notice is upheld. The fact that we can't go behind, I mean, the...
Can that be right? If you, suppose you applied for a 6-foot square cardboard advert, surely you wouldn't be debarred from saying this doesn't cause substantial injury. Why would you be debarred? Like, what rule
You're
of law
not
would prevent you?
debarred. It's a matter of the exercise of discretion, but a valid and, I would submit, significant material consideration that the local planning authority is entitled to take into account, and as it has happened,
Keep going. Don't put in parentheses. Is what?
Is a weighty material consideration against the grant of consent.
What is a weighty material consideration?
The discontinuance notice, where the Secretary of State has found that the display of any deemed consent causes substantial harm.
That would surely be, if in my rather extreme example, we were dealing just with a 6-foot cardboard advert, it would not be a weighty consideration at all that the Secretary of State had found it caused substantial harm on a previous occasion, because that would clearly relate to the hoarding that was there then.
No.
But it would. If we've read it, it does relate to the hoarding.
Yes,
that's there
but the
then.
notice doesn't, my lord. That's the point.
I mean,
Yes, but it's not the notice that creates the difficulty for you. It's the finding of the Secretary of State.
And
If you applied tomorrow for a very small hoarding, cardboard hoarding, you would not have any difficulty getting over the substantial harm problem, or you might, but it wouldn't be because of what the Secretary of State had previously found, because what the Secretary of State's finding, we only have to read it, is related to that hoarding. And you may say there's some rule of law that would mean that you were that the planning authority would be bound to have regard to the fact there had been a finding of substantial harm. Well, I don't believe there's any such rule. It would be a nonsense.
right. So, my lord, I respectfully disagree. And in fact, as it's happened, my parenthesis is precisely what the local planning authority is doing. But put that to one side. The first case is the position is that this is a discontinuance notice, which is not restricted. That's the point. And
Sorry,
well,
go on.
no, sorry.
No, I was only going to say, I mean, one thing that surely wouldn't lie in the mouth of the planning authority would be to say you can't have directional signs, when in their own statement of case they said we're not dealing with directional signs.
Well, I'm afraid planning officers come, planning officers go, and the position is no, they have a finding where directional signs are included in the notice, they are removed, and the only way they can be removed in our submission is if there is a finding that they cause substantial harm. The result of the inspector's decision, we say it's irrational because there is no basis, but the actual result is that there is a notice that is on the basis that it causes substantial injury, and that's the position. So that is, in respect, my submission is that is a material consideration. We can argue the toss and say we want to go behind it. We can run all the points, but we can be faced with the fact that the local planning authority is entitled to take the Secretary of State's decision at its face, the formal decision. It's not obliged to re-argue the case again, and we have to face that prospect.
Well, all right. Even if you're right about that, which at the moment I'm not persuaded by, if you're right about that, it's really marginal. You are accepting my lord's point that you can apply for planning permission. All you're saying is that for the reason you give, it would be harder to get it than it would be if there hadn't been a discontinuance notice and upheld by the Secretary of State in the past.
That's outrageous, because we are given by the law a right to it, and
If it's outrageous, the local authority won't be able to make a finding against you on that basis.
No, my lord, the upholding of a notice that withdraws, it's like my Lord Lord Justice does withdrawal of his permitted development rights. It's not what happens subsequently. It's the fact that a notice which is unlawfully upheld goes beyond its powers, then is legally valid.
Well, how can it be legally valid if it goes beyond its powers?
Unless this court quashes it and says it's legally valid. I'm challenging and say it's not legally valid, but if your lordship says it is, then it's legally valid.
Right.
And the point is, we shouldn't be in a position that it's much more difficult, that we have to go to the expense of applying for express consent and to have an uphill struggle of getting it. Let's put it as low as that. And we know almost certainly, and then the prospect with the local authority of having then to try and appeal and then persuade the Secretary of State to go ahead. Why should we have to go to that prejudice if it's a right that shouldn't have been taken away? That's really the simple part of the case. It's not a case of, well, it doesn't matter, it's been taken away, you can go and take your chances on appeal. But why should we? Why should we? If it hasn't been legally taken away, why should we have to reapply? And the context of the comment by Lord Justice...
Well, that begs the question, doesn't it, Mr. Jones, as to whether it has been legally taken away. Because clearly, if in circumstances where it has been legally taken away, then the uphill battle, the struggle with North Wiltshire that you will have in relation to earlier inspectors' decisions will have to be grappled with. So that really begs that question, doesn't it? Which is where all of this started with your submissions about Putney Bridge.
Yes, but
that's where we started.
Yes, I think the shortest answer to my lord is paragraph 4 of the inspector's decision, 203, and he says it's clear. Page 4.
Sorry, we're back in the core
Inspector's decision. Oh, I'm sorry. I think I've taken it out and put it in the side. Sorry.
Yeah.
Core bundle.
Yes.
Page
203, my lord. Paragraph 4, the inspector's decision.
Yeah. So he approaches the appeal on that basis.
He says both notices were clear that they were issued under Regulation 81B, I in respect, and then it's the unqualified a removal of all deemed consent.
And you're going to come to this notice in a minute, this letter in a minute, aren't you? So should we just stick with Putney to see where we get to on Putney?
So on Putney,
so your starting point is dealing with a much narrower prohibition.
well, the notice. My first point is notice is different. You've seen it. It's a class, as my lord said, a class within a class. The second point is it was common ground that the current advertisement would be treated as illustrative for the whole scope of what was being withdrawn.
Yeah.
That's not this case. Insofar as hypotheticals, this is if one looks at paragraph 17 of the judgment, and it says what lay in the heart of Mr. Edwards' case, and he was for the appellant, is Regulation 81B was a proposition that for a discontinuance notice to be valid, it had to be satisfied that substantial injury would be to all intents and purposes inevitable. No alternative site, location or advertisement relevant could avoid substantial injury, could not satisfy. In effect, his submission was if the local planning authority could not satisfy itself that no hypothetical advertisement might remedy the injury to amenity, the LPA's concern should be dealt with by decision notice under 81A only, and that would have been against the specific advertisement, not the category. And then Mr. Burley, for the Secretary of State, would empty it, would mean that it would only be, on the rarest occasion, the LPA could serve a valid DN under the provision because it would only be on the rarest occasion they could be satisfied that every kind of the relevant category, no matter how small. Now, pausing here, we're not dealing with that. we're dealing with the situation where neither the local planning authority or the Secretary of State through the inspector has even addressed whether the categories in question cause any harm.
Well, on any view, they're addressing whether this particular
Yes.
advertisement within a particular category causes
Yes.
harm. So, is Mr. Bewley wrong on your case? He says, well, 81B becomes pretty empty in practical terms because you could only use 81B if you could show that every kind of advertisement within, well, actually 81B on the face of it deals with all deemed classes, would offend.
My lord, the exchange doesn't apply to this case.
Well, but it might help in working out what the ratio is.
Because the ratio there is, I mean, in a sense, it's the level of detail that you get into. So, in this case, in the Putney case, the discontinuance notice was directed at a particular class and then a class within that class. And then the argument was being run that within all of that you should go through, even though that they'd accepted this was illustrative, you've got to go through every particular hypothesis. And Mr. Bewley was submitting, well, if you were going to remove a class, go through every hypothetical example of that class, it would render it nugatory. That is not my case before this court, and it's never been our case.
Are you saying he's right, but it doesn't apply to this case?
He could, yes, he could be right. For the purposes of my case, he can be right because it doesn't apply to my case and it doesn't affect the ratio. If we apply Mr. Burley's point, he is not saying, nor did it arise in Burley because they were looking at one category within a category. He is not saying you don't have to address the category.
So just to be clear, on any view, your advertisement was in class 6. An advertisement on a forecourt.
14. No. The class 6 was the car park ones that I was illustrating. This advertisement is class.
So you're 14.
We're class 14.
So advertisements displayed after expiry of
Yes.
express consent.
Yeah.
So hang on.
For the purposes of
If the local authority had wanted to ensure that your advertisement was gone and that similar advertisements were gone, what categories would they have used?
they could have done along the lines that was done in Putney Bridge.
Well, tell us what that is.
You specify the category of class that you are withdrawing.
So what would you would have needed to withdraw 14 and 6?
Well, you'd need to have drawn that and the list that the list that the list that is in Mrs. Jones's.
Well, is that right? Because you say, well, what she was making the point that this catches all sorts of other advertisements. But if you want to catch advertisements such as this one, what classes would you prohibit? What?
Yeah, you just go against the display itself.
Well, that's 81A. But if you want to make it more general, you want to go for 81B.
Well, I'm not.
So I'm just trying to understand whether Mr. Bewley is right, effectively, that it doesn't work because in any particular class that you might want to prohibit, you've got to produce examples of why even a tiny thing would be objectionable.
No, what would... No. What? I just... But I've got an answer for this. So, the first thing to recognise about these categories, the ones that of consent, the one that we're looking in class 14, which is the present advertisement in this case, is one that's already been given bespoke consent.
Absolutely, but the local authority says, we don't like that advertisement and we don't want anything similar either. So they want to withdraw, on this hypothesis, deemed consent for the relevant categories that will catch the sorts of things that you want to put up there. So which categories do they then say you
I
can't
don't
have?
think it. If they want, if they don't want this advertisement that has deemed consent because they already gave it, it was already given express consent and left. They specify and remove that advertisement. We can't then put up another advertisement of that type without seeking express consent. That's Justice Coulson's thing. But you don't then take away all these other areas.
No, well, he's not saying that, is he? Well, if you say if you go against this particular advertisement, that's 8.1a, then there's no prohibition on any other advertisement. You've got deemed consent for everything.
No. No, I don't have deemed consent to put an illuminated advertisement. The only deemed consent is the categories that you see in the deemed class.
Okay, so
They're no. Well, if you look,
you're allowed an advertisement on the forecourt of business premises, or which categories would be relevant?
so if we go back to the passage, I mean, legally they're all relevant because they're all court. But what Mrs. Jones did was practically indicate the categories of advertisement that.
Well, we saw that.
Yeah, okay.
Yes.
So
It's in her
Yes, but where?
supplementary bundle.
so this is paragraph 2.8. It's page 9.
At the front of the supplementary bundle.
So
And then we can then go and we can then, if your lordship's
can we-
like, we get the authorities bundle and look at each
yes, you're
classes.
quite right. We should do that, but just so clear. So let's suppose you have a local authority that doesn't like this advertisement and it doesn't want anything comparable put up.
Right.
So what classes must it exclude to assure that result?
So,
Well, I think the point would be that you would not have had deemed consent to put up what is actually now on the site. You only
Right.
have deemed consent because the time period for that scale of advert that you put up, time period on the consent expired, and it wasn't removed, and that's what brings it within class 14.
correct.
Most of the other deemed types of advertisements are limited in their scale, much more limited than this advert.
That's correct. I can take you, just give the flavour to the other. I know my Lord Justice knows,
He
but
knows
to the
that
others,
more than we do.
it's to page 29 of the authorities bundle. And you'll see, although we've just put the headlines, there are all conditions and limitations as to height.
I see.
So,
So I haven't got there yet.
as authorities bundle 29. So if we went to, let's,
Hang on 1 second.
yes.
Yeah.
So we go to, for example, let's go to, since we've been talking about it, page 34, advertisement on the forecourt of a business premises.
Yeah.
And then you'll see conditions that advertisements displayed on forecourt in the case of a building with a forecourt on 2 or 4 more frontages. And each of those shall not exceed an aggregate of 4.6 metres square in area. 2, illumination is not permitted. No character or symbol of that more, and well, I won't read them all out, but you can see them. So that's why we're saying, if this is your concern, why are you taking all these other things away? What's the justification for this very draconian measure? So when that's gone, my client will, it doesn't sound rude, but why should they have to apply for directional signs on that site and face an uphill task with Wiltshire and all the others? Why should they even go to the cost?
Well, because that having found, it may be said against you, the sensitivity of the site to be such as it is and the importance of the regeneration strategy such as it is, the local authority would then have control over even more modest advertisements, like, for instance, as my lord has pointed out, on the forecourt of business premises that might arise in the context of any redevelopment of the site.
So my answer to that, my lord, is, and I say rhetorically, I'm not asking your lordship, but I'm sure my learned friend will take us to the paragraphs in the council's evidence, the notice, and in the inspector's decision where that sort of reasoning is set out. And the answer is no, it's not there. And with great respect, it's not for this court to then make another case and another decision. And that's precisely what's missing through the notice, through the evidence and through the inspector's decision. Now, I realise, in a way, I can understand the courts, this is not, may not be, necessarily seen as attractive. But the point is, this is the draconian steps where a local planning authority in the Secretary of State bears a heavy burden, high test, to take away rights, included in the notice where it goes beyond that which is justified, has never been justified, and never reasoned. If it were the case, my lord, that a case was being advanced, that suddenly this area has become so sensitive, and I'm not going to get into the merits of the case, it's not in a conservation area, it's not in blah, 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 suddenly becomes so uber sensitive, then we're asking, where is that case set out for my clients who have argued, and then for the inspector to have made a decision on it?
And I think you've covered all this ground, but just let me pursue it a moment longer. So let me just take Class 6. As you say, it's subject to limitations. You can't have anything exceeding 4.6 square metres in area, and you can't have illumination, and it can't be... No, well, a character or symbol can't be more than 3/4 of a metre, and so on. So suppose the local authority says, we don't like this thing you've got, and we don't want it replaced by something that is 4.6 square metres in area. What do they do?
Well, they make that clear, first of all, they actually address their mind to it. And then if they want to remove a deemed category, you see where it's set out in its categories, they can include it. And then if you appeal, you can argue the toss.
So then you would then have to exclude Class 6 in its entirety.
Well,
and then
no,
you would
Putney
come
Bridge
along and
shows...
say, well, if you're excluding Class 6 in its entirety, that can't be right unless you can explain why some advertisement that is 6 inches high.
No, we would have a case in front of the inspector to argue that point on the merits, as you do. We wouldn't be able to come to the High Court or this court saying, oh, as they did in Putney Bridge, and say, what about this, what about that? What they did in Putney Bridge was never going to work. They'd already agreed the category within the category that what was there was illustrative. Their only difference was it nice or was it not nice? I mean, I'm simplifying it. But if, for example, a council decides that it wants to remove categories, and it's not the case of hypothetically having to root around for a made-up advertisement, they're all set out in detail. So you put the category in, and the council satisfied itself that advertisements within that category cause substantial injury. Now, if we come up and say, well, can the notice be varied? Bearing in mind, Putney Bridge was a discontinuance notice, not for all indoor advertisements, but illuminated. We could argue and say to the, argue that point before the inspector. But in this case, not only are they not even mentioned, the council doesn't even advance any justification. There's nothing there to hit back at. There's nothing to have.
You made that point.
Yes, well, I was trying to answer my lord's point. That's why Mr. Bewley's point doesn't really arise in this case.
Yeah.
And it's there is a text. I mean, this is there's one leading textbook on the law of advertisement control.
Are you leaving Putney?
I am, my lord. I don't.
But have we actually identified the race yet?
I think that in my submission, the ratio is well. the Court of Appeal's reasoning in Putney, and if I can make these points. First, paragraph 17 for your lordship's note, the submission regarding hypotheticals, relevant categories or categories, frames the conversation regarding hypotheticals, but in the Putney Bridge case, it's in the context that the category had already been defined.
I follow that, but the ratio is what reason the court treats as the basis for its decision. So one can make all sorts of points about the context, but one has to look to see what reason the court treated as the basis of its decision.
So help at para 38, what the judge does in his conclusions is he approves the inspector's self-direction which he set out at para 8. Does that help us identify the
yes, I was going to go to para 27, but I'll go to deal with that point first. Para 8 of his judgment.
Well, I was
yes.
The main rather than suggesting.
No, it's sidelined para 38 143. Under the heading main issue, the inspector said at para 4, the main issue is whether the continued use of the site for display of advertisement deemed substantially injurious to amenity. At para 7, she said the test and regulate requires that there must be substantial injury to the amenity, to the locality, to the members of the public. There is no danger to members of the public in this case. And then, having set out her planning judgment, para 29, under the heading, the notice requires the discontinuance of the use of the building for the display of illuminated advertisements with deemed consent pursuant to Class 12 of Part 2. Given the location and orientation of the building as a whole, I consider for the reasons above that any illuminated advertisement on the site was substantially injurious to the amenity of the locality. I think I've already addressed the whole context of what the Court of Appeal is approving. Her approach is in respect of a class within a class identified in the notice to which the parties had agreed was illustrative of that category to which the notice bit, which was any illuminated advertisements. In my submission, obviously she was plainly right to come to that conclusion. And if one looks at paragraph 27, the proper width of an inquiry in the Lord Justice Coulson's decision, he deals with Mr. Edwards' submission that the effect that since the discontinuance notice and appeal decision related solely to particular advertisements that are on display on the site, that was insufficient to permit the service of a valid decision notice under Regulation 81B. The point Mr. Edwards was making, he said that for decision notice to be valid, the local planning authority and subsequently had to be satisfied there was no possible advertisement that could be displayed on the site without causing substantial injury to the submission of the locality. That is not the submission. That is a very different submission to this case. He's saying, rather belatedly, that the case was had to be, if the case was determined on the particular advertisement and the facts of the particular advertisement, which after all they had agreed, it couldn't be dealt with under 81B as in relation to the site. That's my understanding of his argument, which in my submission is plainly wrong.
Well, he said, according to Lord Justice Coulson, he says that for the notice to be valid, the planning authority and the inspector have to be satisfied that there was no possible advertisement that could be displayed on the site without causing substantial injury to the amenity of the locality. So that must mean in relation to whatever class is identified in the decision notice, which could be a particular class or multiple classes or the lot.
Yes.
He's saying the notice won't be valid unless there is no possible advertisement that could be displayed without causing the injury.
But that's not my case here. This is not our case. Our case is in a notice which is different to the Putney Bridge notice, which applies unrestricted to the whole of deemed class categories. You have to include not only reasons, but evidence, a case to sustain those other categories.
Isn't the problem just the same whether it's a very inclusive notice or a category specific or subcategory specific notice? The problem is the same. Have you got to exclude other possibilities which would be caught by the notice given? And that's the same whether the notice given is very wide or whether it's comparatively specific.
My lord, no.
Well, why not?
So in this case, you had a category within a category. So you're saying this.
I see that. I see that.
This category.
But the dispute was whether within that category, within a category, you had to consider alternatives.
Yes. In this.
And he says you don't have to.
Yeah. So that category is caught. In this case, we have class 14, which is the advertisement which it applies to. There is no suggestion at all that any advertisement, it's the other way round, that any advertisement within those classes would cause substantial harm.
I think my Lord's point is really based around what Lord Justice Coulson says at paragraph 32 of his decision, of his judgment. So I think the proposition is that as per paragraph 32, it becomes practically entirely unwieldy for the inspector, having concluded as he did in relation to this advertisement under class 14, he then had to work his way through all of the other potential classes within Schedule 3 in order to imagine what they might be like on the site and exclude them, as opposed to making a general finding in relation to the importance of the site and the amenity of the area.
In my respectful submission, it's not the same, and it's not a practical difficulty. The question in Putney Bridge was related to one category, of which the inspector had found the advertisement did cause substantial harm. In terms of the way the regulations work, they distinguish between advertisements and also, as we see, categories. In this case, there isn't much, and this is not a case where we kept silent. We actually raised the specific categories that could be met. And it's not too difficult. Then you then say, as inspector, to the local planning authority, here are these cases. Why are you saying they should be caught by the notice? And they could. And, I'm sorry. And then there's got to be some evidence about it. They were in play. They'd been raised in the appeal statement. They'd been raised before and saying these are categories. There's no justification for them. We know, for example, that the council, in the odd, I know it's slightly inconsistent, on the directional notices seem to be accepting that they may not cause substantial harm or what. It is unclear. But there needs to be, before you withdrawing these categories from it and saying, well, these categories would nonetheless, the site's so sensitive, as my Lord Justice Duff said, and there's a finding that even these categories as a whole, and if there are ones within these categories that would be all right, then you apply, as Lord Justice Coulson says, for consent. But if there's no indication at all that any of these categories would have any harm, it's not that difficult to look down the list of the ones that Mrs. Jones applied and apply your mind to, would a forecourt sign within, would this cause substantial harm? You don't, I'm not submitting that you have to say there's nothing within the category that might not cause substantial harm. If they were able to say that there are advertisements within for example, Class 6, that we think would cause substantial harm, that's good enough.
Can I just approach it slightly differently? As you were sort of applying earlier, on the face of it, 8.1b would normally be expected to apply to all deemed consents.
Yes.
Putney was different because they narrowed it.
Yeah.
But on the face of it, it applies to all deemed consents. And indeed, this notice here applies to all deemed consents. So relate that to paragraph 32. I mean, the problem is worse, isn't it, if it applies to all deemed consents rather than to a category of all deemed consents?
No, because this is the inspector does. I am not suggesting that in order to uphold a notice that includes a deemed category, the inspector has to be satisfied that there are no advertisements within that category that could cause substantial harm. It's quite important that the court understands that's never been our submission. That's not our submission. Our submission is, in order for those categories to be included, there has to be at least some evidence that an advertisement within that category could cause substantial harm. So it's a complete reverse.
Yeah, don't worry, keep going.
So, for example, and this is not a difficult test, let's just restrict it to the ones that the appellant raised in their evidence. You look down that list, you have the schedule open, you have the limits, and you think, is it possible that an advertisement within this consent could cause substantial harm?
So is the position, while 8.1b on the face of it refers to withdrawing all deemed consents, actually you can't use 8.1b in that way, in practical terms, because you're going to have to choose particular classes and look at those particular classes.
You could come to the view that the display of any, let's take an example, one could think of a, I was trying to think of an example of a site that's so sensitive. I'm just going to, people may do, let's say it's Buckingham Palace Garden, right? You can conceive that it would be, or in a, you know, an immediate area.
Flags there.
So, yeah. But this is the problem you're going to. But New King wants to raise money for the environment.
So there may be the odd case where you could use 8.1b as you might think it was intended to be used, but it would be very rare. Because otherwise you have to show that there is something in every single class that could be objectionable.
Well, I mean, you could deal with it very easily. I mean, I'd ask you to look at, I mean, I don't want to take you all through the classes. There are some that just, in reality, would plainly not apply because they're so specific to the, so you could deal with them very easily.
Isn't that a point in favour of the obverse, which is that because they are so specific, for instance, government departments, etc., that actually the appropriate approach is to make the notice and then call for an application.
Right, well, no, I'm just going to repeat the same thing.
I know you are.
It's an abuse of power. I mean, it's a classic. No, with respect, my lord, it's a classic. If that was the position would be you can issue a discontinuance notice, no substantial harm test, the same test, and then you then just everyone applies for consent. That isn't, you know, the Secretary of State could have done that, hasn't done that. So my submission, that's just, rewriting the legislation for administrative convenience. The position here is I am not suggesting, it's quite a fundamental point, and I don't see that it's so difficult at all, given when you look at the mandatory nature of the notice, you look at the categories, and you say it's a different thing. It's not, is there any potential evidence it could be, but you're excluding a category, and therefore you say, is there, why am I excluding it? If I can't think of anything under that category that would cause substantial harm, why am I excluding it? I mean, that's a question I would pose. Since the burden is with, the burden, and there's no dispute as I understand, nor can it be, the burden is with the Secretary of State and the local planning authority. If they're withdrawing rights, they've got to justify them. And the question then becomes, is not the question that arose in I'm not submitting what Mr. Edwards submitted, that you've got to exclude you can't exclude anything unless there's some hypothetical. I'm saying you've just got to, if you're excluding categories of deemed consent, just apply your mind, is it possible this could cause substantial injury? How difficult is that? You look at the category, is it possible? And that would be good enough. It's not the hunting around with hypothetical advertisements. The other point is, how then when you appeal a notice that goes beyond and no evidence, how do you actually then run a case? You then have to run a whole set of hypothetical adverts in the discontinuance notice appeal and say, well, that would be all right, that would be all right. I mean, that's equally absurd. But that's what the result, if your lordship upholds this approach, that is the approach that on a discontinuance notice, which you've got a merits appeal that goes against the whole of the notice. If your lordships are right, every time someone has got to then, the burden is reversed, and to preserve their rights, they'd have to come up with hypothetical adverts and say, oh, well, this forecourt one would be okay. What about this flag? What about this? What about that?
And instead of that, the inspector's got to do it.
No, it hasn't. No. Sorry, I've got to say this again. The local planning authority, the first part, has to justify and just say why the category, anything within that category, could cause substantial harm. Why is that so difficult? It's a category. Why is it so difficult to justify? You don't have to get into hypotheticals. You say anything within this is anything within this could cause harm. So you can just take what you just say. You look at the conditions and you say, we say an advertisement that could be the maximum, could cause harm, end of. We take the category. That's good enough. But if you go the way of the Secretary of State, any discontinuous notice appeal would mean everyone has to run to preserve all these hypothetical consent points. And that's to reverse the whole thing is about who bears the burden here. And the burden, I am not saying what was run in Putney Bridge. I accept Putney Bridge that you can have this category, but I say in the category, there has to be, if you're taking successive categories, you have to say that anything, an advertisement that could fall within that category could be harmful. I am not saying you have to say no advertisement. You don't have to prove that every advertisement within that category.
You are quite a long way from 8.1b. 8.1b is you can serve a notice if you object to the use of a site for the display of advertisements. And you say, well, you can't just do that. You have to think about every category and exclude categories in relation to the site.
So what I would have possibly have said, but for Putney Bridge, is when you look at the structure, it's clear that there's a distinction between advertisement and the site. But Putney Bridge says, this is the notice they did, that you could target a category under 8.2. But that is different. See, this notice in Putney Bridge is the ratio of Putney Bridge is not the notice which only dealt with illuminated advertisements inside a building justifies a notice which removes all deemed consent from the site, because that notice didn't. It never did it. Now, and it doesn't say that, and it doesn't give any over to dicta saying that could have been done. And if the Putney Bridge decision on allowing that sort of slight composite is seen as lawful within the regulations, within its scope, fine. But then what you can't do is just justify on basically one advertisement the removal of the whole unless you give reasons why those. It's kind of as simple as that, really. And so that's really the point. So I just want to, as I say, make very, very clear, I am not running Mr. Edwards' case that, well, I'd be silly to do it anyway, but I'm not running his case. And ours is, we say, completely the reverse.
You've said this about 3 times already.
Yeah, I know, but I keep getting, well, I would say,
Distracted by the court.
well, no, I don't know.
Sorry, I didn't mean to be rude, but
No, I don't know, because it's put back to me that I'm arguing something else. I just want to make it clear. It's continually put back to me, or I'm misunderstanding what the court's putting to me, that that paragraph 32 deals with. No, it doesn't. So I just have a look. I'm not sure. Yeah, I mean, if it helps, I can just list the 5 principles we say that comes from Putney Bridge. The first is an inspector on an appeal under Reg 81B notice must determine whether it's appropriate to remove deemed consent from adverts of the relevant category or categories. And that's named the categories of deemed consent, which are the subject of the notice. And we say that follows from the test of necessity and the test to give reasons. Then second, we do say it's important to see the distinctions. There's a distinction between, one, considering every hypothetical advertisement within a specified category, higher, lower, less bright, which is not required per Putney Bridge, and which is not our case, I'll explain. And 2, considering the full effect of the notice on which Putney Bridge is silent, and Putney Bridge's authority, we say, for the proposition, it doesn't permit an inspector to not consider the effects of the notice.
This is your third point.
Yes, under proposition 2.
Oh, sorry, it's not your third proposition. Sorry, it's all part of 2. Carry on.
Broke it into
my
3.
note clear. Yep.
Sorry, it wasn't my second. There's an important distinction.
Yeah, I've got that. But
yeah. Second, considering the full effect of the notice on which Putney Bridge is silent, but we say Putney Bridge is authority for proposition 1. You don't, but it does not permit an inspector not to consider the effects of the notice under proposition 2, which is considering the full effect of the notice. So that's our second point. Third point on Putney Bridge. The parties' cases may be relevant to determine the appropriate width of the inquiry. So first, whether an inspector can treat an advert as illustrative of the issues caused by that category. That was common ground in Putney Bridge. And secondly, whether an inspector can practically address the question of whether other adverts of that category might be appropriate. So where, if it was a different case, where a party did say within the category there are distinctions, if they raise it, then obviously, like any point, the decision maker deals with it. But and then fourth, in determining an appeal under 81B, where parties have been content to treat a given display as illustrative of that category, an inspector won't err in law in considering whether that display gives rise to a general problem. And then lastly, the appropriate width of inquiry will always be determined by the terms of the notice, having regard to the above principles. And so I'm just going to give if we go to the decision letter, I'm just going to give subject the paragraph references and what we quickly say about how it was dealt with. Decision letter is for bundle 202. So I've already referred to paragraph 4. I don't need to repeat that. Paragraphs 31 to 34 of the decision letter. When your lordships get to it, your lordship will see it's focuses in this appeal on the single display throughout I won't read out the paragraphs, but it's focused on paragraphs 31 to 32 in particular. You'll see.
Sorry, I've got completely confused. Which page are we on?
207
Thank you.
of the main bundle.
I see your inspector's decision. I thought you said the decision letter.
No, yeah, the decision letter. Sometimes it's called the.
Oh, is it? Okay,
inspector's
I've got it.
decision, sorry.
Yeah, right. Sorry. Yes, I'm with you now.
So paragraphs 31 to 34, I won't read them out, but your lordship see a clear focus on the single display throughout. In particular, paragraphs 31, 32, it's reference to the display. And then paragraph 33, there's more generally, the final sentences, more generally, the use of the site for advertisements significantly undermines the attractive nature of much of the residential and other forms of built development. And that's a reference to the advertisement displays. We, looking at that, just because it's relied on by the Secretary of State, we say when you read that paragraph, it's clear.
Which paragraph?
Paragraph 33
Right.
this is it's a statement. There's no reasoning at all attached to that. No evidence for him of any of the other deemed classes of advertisements, nor was any advance before him in the case. And indeed, if one refers, I just give you the reference, the judge below, we agree with this, well, he says there was no detailed attention. This is judgment para 36. I'm just going to read the sentence, but your lordship, without going, no detailed attention paid to how the other advertisements might interact with built environment. I mean, it's not detailed, there was no consideration, no analysis. And when you look at paragraph 34 and all the analysis, it's all related to the specific display. And if we do look at, as we say, as a judge himself found, the decision letter and the judgment you'll find begins at paragraph 62 of the core bundle. 62.
Oh, you said paragraph. You meant page. Sorry.
Page 62. I'm sorry.
No problem.
Of the core bundle. I accept during the course of the appeal, the inspector was focusing attention on particular display.
Which paragraph?
Oh, I'm sorry, paragraph 36. He says there is some reference, and this is a reference relied on by the Secretary of State, to the use of the site for advertisement displays, and that's para 33 that I've taken to, which appears to be a reference to advertisements generally and not simply the particular display. But there's no detailed attention paid to how the advertisement might interact with them, and no suggestion that the site is wholly suited for any advertising of any kind. Now, since you're removing a batch of deemed classes, in my submission, there needs to be evidence in relation to those deemed classes. Anyway, repeat the point without repeating. Then, in our skeleton argument, we just, and I just say why, for form's sake, the judgment was wrong below, but I'll deal with it shortly because it involves repeating a lot of what I said, so I won't do. It's at our skeleton paragraphs 42 to 67.
Which page?
My skeleton, it's...
Starts at 18.
It starts at...
Did you say 46 to 47 paragraph?
Yes, it's paragraphs 40. No, paragraphs 42 to 67. I'm just going to give. I'm going to deal with it lightly and just highlight the paragraphs in each particular point. So paragraph, say 42 begins at paragraph. It begins at page 35. Our submissions. So the inspector's approach in the appellant's case, we deal with at 44 to 46. I don't need to repeat that. And then we at 47 to 60 we highlight, and I don't go into detail. We've made it the statutory requirement to consider necessity, and we deal with the distinction between deemed and express consent at para 61 to 67. Dealing with the point, it's always, again, I can deal with this, I hope, quite shortly because it's been put to me in any event. The judge's below point, it's always open to apply for express consent, and nothing inherently unfair about removing all deemed consent. I just say very shortly why it's wrong. I've made the point, discontinuance material to any subsequent application. It's not how the regime worked, as I put in submission, and the tests are different. So we say the judge was wrong for five reasons on this point. The consequence of the inspector's decision is every time.
Sorry, where are you reading from? Or
I'm just giving you the points.
oh, sorry.
From
Yeah.
I'm just giving 5 points now. The inspector, it's wrong because the consequence, we say, is that an inspector's decision is every type of deemed consent is now found to cause substantial injury at the site. The tests are lower, as we've said. Third point, the LPA is restricted to amenity and public safety when determining this express consent, so it can't weigh in all the other planning factors, public benefit, economic utility against the deemed substantial harm. That's why it's such an uphill task. And then fourthly, the finding therefore renders any future express consent almost bound to fail in the absence of material change circumstances. And we say it frustrates the advertisement regime that gives deemed consent to these other categories. Then fundamentally in public law terms, we make these points. It's a statutory requirement for reasons in the discontinuance notice, including why the entire site. I won't go back to it. I took your lordships to regulation 8A. If one looks at it's acknowledged by the inspector when you go to 4 that the appellant raised the defective nature of the notices, and then we then say the critical issue is the burden, and it must say why the discontinuance notice is necessary in the terms that it's made, and that rests with the decision maker, and that's clear from the legislative regime, one, and the categories. We say both the inspector and the judge was wrong about Putney Bridge. It doesn't obviate the need to justify all categories, and I've explained the reason there. I'm not saying everything. Well, I've explained that my case is. They just need to look at the category and say, could this cause substantial harm? And that's good enough. They don't have to do what Mr. Edwards was arguing. The appellant made the case and put best evidence they could before the inspector, but this case rather highlights the difficulty with the approach. If nothing is said about those categories as to why it's said that they're harmful, how can you, if the burden is on the appellant, how can you meet a case where the party that has the burden doesn't call any evidence and is found not to need to? We then say if the respondent and the judge are correct, the distinction between 8.1a and 8.1b are almost nugatory. In either case, on the respondent's construction, all that needs to be considered are the displays on site, or if there are any particular alternatives proposed by the appellant. In either case, we say, despite the statutory language, is a decision maker obligated to consider whether the notice is drafted is necessary to remedy substantial injury in respect of everything it discontinues. So that's in the judge's and the respondent's case. And so the result is a local authority could always just issue a notice under Reg 1B if it's concerned only with a specific display, and then just justify it on that basis. And there is no requirement, therefore, if you take the judge's approach and the respondent's case, to put forward a positive case as to why the actual full scope of the notice is justified. Why is this, for example, Manchester gone further than the local authority in Fulham? Why we say the respondent wrongly miscasts our case, we are not saying, and I don't need to repeat it, but we reject the suggestion that the inspector needs to consider every hypotheticals within a class. And if one advert is illustrative of the effect of the whole, and that was clearly what was in Putney Bridge, that was agreed, that was a finding, that was clear. But if one advertisement is not illustrative, then the full effects of the notice need to be considered on the categories. At least, as I've said, in a broader effect. If it's one advert, and it's one, as in this case, that only has deemed consent because it's bespoke, left over from express consent, then it can be addressed under 8.1a. At para 32 of the respondent's skeleton argument, it seems to concede that if the appellant had advanced arguments as to any specific class of advertisement might not fall foul of the inspector's reasoning, the inspector might well have been obliged to address those arguments. The appellant raised in its statement of case the fact that there was no justification for any of those particular classes, no case had been put forward. Even in rebuttal, the council just ignored it. The inspector made no findings that doesn't mention any categories. But if it's right then, as my learned friend says in his skeleton argument, that if we had advanced it, they'd be obliged to consider it, then all the arguments about hypotheticals goes away. I mean, it's not the argument I'm running anyway, but my learned friend is right that it would have to be considered, but it's a wrong submission to make because the burden is on the person taking it away, not the person advancing, seeking, as you do with express consent. And that concession rather highlights the point I made to your lordships a while ago, that if this is upheld, then the position in appealing discontinuance notices becomes very difficult. The respondent says, we identified but didn't argue, this is para 33, that the appellant did make arguments, and I just refer back to the statement of case and the respondent case. They identified the likely deemed classes that would be affected. They identified that neither the notice and then the evidence addressed any of these points. And there is nothing further you can say. If it's not being alleged, or there's no case being put forward that there's no harm, and you make it clear that that is, well, what more can you say? And that's because there's been a mischaracteristic of where the burden is. And if the nature of the submissions made to the inspector that it couldn't be shown to be necessary in the full range of deemed consent, then that should have been addressed. But the burden rests on the decision maker to be satisfied the burden's discharged. The appellant was entitled to point out that no case had been put in respect of these categories at all, and to say that the burden is not discharged. And the respondent, on casting around for alternative, relies on planning cases, which are relied on via Putney Bridge, para 30 to 31. I think I've dealt with this. Is not required to cast around for alternatives, not suggested. But this is, we say it's irrelevant for the three points I just made very shortly. Those cases concerned conditions and alternatives that were simply never raised before the decision. Here the appellant raised them. We're not coming along and saying, what about these? Deemed consents only at High Court. They were all raised. They were raised even before the appeal was made. The principle in Findlay and Top Deck only protects against an obligation to stray beyond the party's case. It doesn't protect a decision maker from the obligation to address a point that was placed before him. It was placed clearly before him that no case had been made in respect of these deemed classes. It's just not addressed.
Now you really do need to wrap up within 30 seconds.
That's it. Because the last one I was going to say was impracticality, but I've already done that.
So my optimism at the beginning of the morning.
I'm sorry.
No, well, I think you've been responding to matters raised by the court, but we better just work out where we are. We absolutely have to rise by 3:45. Mr. Dale Harris, how long do you think you will need to be?
My lord, I would hope not more than half an hour. There's a little bit
I can
more
see we've been through a lot of ground already.
Indeed, my lord. So I'd hope half an hour, maybe 40 minutes.
Yes. Well, that sounds encouraging. Thank you very much. In which case, 2 o'clock.
What,